This case number 115343, State of Kansas v. Gabino Ruiz Asensio.
Good morning. May it please the court. Rick Johnson for the appellant. With me is Vincent Rivera. Mr. Ruiz Asensio went to trial in Lyon County for murder in the first degree, attempted murder in the first degree, aggravated assault, and illegal use of a communication facility. The jury found him guilty, and he was sentenced to the hard 25 on the murder in the first degree charge. We have two issues pending before the court. I'm only going to argue the first one. The second issue is a sentencing issue that the state is also in agreement with, that the court improperly imposed a lifetime supervised release. The first issue on the case is the one I'm going to be arguing this morning, which is our argument that the court erroneously failed to submit a voluntary manslaughter instructions to the court. The facts of the case are this. There were three gentlemen, a person named Chris Van Tussel, Adrian Peralta, and Aaron Gurley, who were looking for methamphetamine. And as they were making their phone calls, looking for various suppliers, one of them, I believe it was Aaron Gurley, suggested that they contact Mr. Ruiz Asensio. They were able to get a hold of him. He came over to Van Tassel's house with cocaine. I believe that he may have sold some to them. They certainly used cocaine at the house, and Van Tassel was upset that cocaine was not shared with him. Because of that, there was at least an argument of some sort there at Van Tassel's house. It was described in various ways as to how heated it may have been, but nonetheless it resulted in Mr. Ruiz being kicked out of that house.
Can I ask a question
Yes, ma'am.
right there? Because in your brief you say, while at Van Tassel's residence, Gurley called Coy to inquire if he wanted to fight with Mr. Ruiz.
Yes.
And then the next sentence is, this led to a minor argument between Peralta. So you seem to say there that there was a connection to the possibility of a fight that caused that argument, and now you're saying it's kind of unclear.
There are two perspectives on that, and there is contradictory evidence in the record from the various witnesses. And our standard of review on this is de novo, and the court's going to look at the facts in the light most favorable to the defendant, which means that we're going to disregard contrary facts. But regarding the fights... In the light
most favorable to the defendant, or
to the defendant in analyzing a failure to submit a lesser included instruction.
It was requested.
And it was requested, yes. Otherwise, if it had not been, it would be a clearly erroneous standard, but this is properly preserved for this court. There are two arguments at Van Tassel's house. One, I believe, if we look at the record, is the argument about wanting to have a fight with Coy. I don't believe that Mr. Ruiz Asensio was part of that. I believe that that was a separate argument among those gentlemen that Mr. Ruiz Asensio was not part of. There is also evidence on the record that Van Tassel was upset for not receiving any of the cocaine that was supplied at his house, and that is why he kicked out Mr. Ruiz Asensio. I know from reading the record that Mr. Ruiz did not have any knowledge that there would be an attempt to arrange a fist fight or an assault at Coy's house, Gurley's house, when they arrived there. So I believe that these three gentlemen discussed trying to arrange the fight without Mr. Ruiz's knowledge, and then only...
Well, you believe. Was there any evidence to that?
Well, it was contradictory. I mean, that's the thing. I mean, these witnesses were not... they were inconsistent with each other, and it was not entirely clear what it was. So yes, that's what I believe. I will say that the record supports that. And that there was there at the residence among those three, but not with Mr. Ruiz, at least a plan to try to arrange a fight with Coy. And we know from the record that Mr. Ruiz was asked to leave the residence, which he did, and he left with Peralta and Gurley. When they left the residence, they went to Mr. Gurley's house, which is where Mr. Coy lived. Apparently, Mr. Peralta was the one really who was instigating and trying to start a fist fight, or essentially make arrangements to have Mr. Ruiz assaulted out in the backyard of the Coy-Gurley residence. Mr. Ruiz was not aware that this was going on. From the record, we find that it was only when Coy and Peralta, Coy exited the residence onto the porch with his girlfriend who was going to watch the fight, and they directly confronted Mr. Ruiz in the yard of that property, which is where the shooting took place. We know at that confrontation, there witnesses are not consistent with each other. There was some testimony, and I believe it may have been at the preliminary hearing, and I can't remember if it was the trial or the preliminary hearing, that Peralta lunged at Mr. Ruiz.
Well, no, that's mischaracterizing what happened and what the statement was. There was a statement on a second interview with Peralta that said. It wasn't Peralta, but it was another witness that said that that he walked towards the defendant, and then at trial and at every other subsequent hearing, he said, that isn't what I recall.
Sure.
I recall walking away, and it's that one statement that was talked about at preliminary hearing and then at cross-examination, which he denied. That's really the only evidence you have of any kind of confrontation or any kind of movement towards the defendant.
There is the prior inconsistent statement with the steps towards the defendant, and I characterized it as a lunge. And I wrote in my brief that he may have lunged at him, and certainly there's inconsistent evidence that he took a step towards him. But there's a second piece of evidence, Your Honor, that has also helped corroborate the idea that he moved towards Mr. Ruiz, and that's the stippling from the pistol on his abdomen, which shows a close proximity. I know that the defense did not call ballistic experts talk about stipple marks, and I don't believe, I'm trying to remember now as to whether or not the coroner testified about stippling and the proximity. And I honestly don't remember right now as I'm standing here and thinking about it whether or not he did.
Well, let's get to what the statute requires, and it requires that it's knowingly killing a human being upon sudden quarrel or in the heat of passion.
Correct.
This was an ongoing dispute between at least the two of them, between Coy and the defendant. How is that a sudden quarrel when it's an ongoing dispute? Not only there's evidence, in fact, that the first charge of the assault occurred 30 days later, saying I'm looking for this guy, and then it's ongoing for 30 days. Even that night, it's ongoing. How is that a sudden quarrel?
Because the physical altercation itself was sudden, and it happened in the yard. So we don't look at it and say, well, it starts at this point, and then there is this heated or ongoing dispute that travels over a period of a month. We look at the fact that he was ambushed in the backyard by Coy and Peralta.
And he's the only one with a gun, and he's saying, go ahead.
I understand that, Judge, and that's why we're dealing with the issue as to whether or not there was a voluntary manslaughter charge. Somebody died, and the fact that he had a pistol and ended up shooting somebody, our argument here is that the jury should have been able to consider whether or not he committed a crime that was not murder in the first degree. So we're not excusing the pistol and the use of the firearm in this. But there's no evidence that Mr. Ruiz went to Coy's residence with the purpose of killing somebody, or even with the purpose of engaging in the physical altercation. In fact, the contrary is true. What we've learned is that, from the record, is that there was no indication to Mr. Ruiz that they had planned to assault him in the backyard, that he expected of it, and that he had any idea that this was going to occur until Coy came out of the residence and Peralta participated in the confrontation. And so, At that point, then, we have a sudden event. We have two people who are lining up to assault Mr. Ruiz in the backyard of the house, and that is the type of thing that can constitute a sudden quarrel sufficient to give rise to the sudden passion. That's the element of the crime of voluntary manslaughter. In sudden quarrels, when you think about when the courts write about sudden passion and what types of emotions are sudden passion, and we talk about not only anger or hatred or retribution, but also fear and terror. And when you're talking about two people who are about ready to confront you with a beating and who are going to assault you, and the amount of fear that would be going on, Mr. Ruiz's statements to the assailants that he didn't want to fight, at least from the record, it appears an indication that he attempted, while not the best way to defuse, it certainly was to use the pistol as a threat to say, I'm not fighting. And it appears from the record as though Peralta at least got close enough to him that there's powder marks on his skin from the pistol. And when the pistol's drawn, there is the statement by, I believe it was Peralta, not Coy, who said, I don't fear death, which indicates I'm going to fight you no matter what, and even with the pistol. So I think when you look at somebody being put into the position of a confrontation of that sort, the amount of fear that may be involved with it, the fact that there's multiple assailants, and it may be that there was some dispute between them previously, but adding to that now, knowing that suddenly this has risen to the point that there may be a fist fight, and fist fights can result in very severe injuries. We've certainly have seen those.
It just seems to me that the 6 witnesses that were there, all of them really said that your client said nothing. He just pulled the gun and fired. And that's pretty much what the trial evidence was.
It is not, pretty much is not entirely what the trial evidence was, and there was contradictory information. There was contradictory...
only from a cross-examination that said maybe he moved forward, and that evidence was contradicted by the declarant who purported to have said that to an officer who was investigating at the time of the crime.
Sure. Plus the stippling, plus the statement of death, I don't fear death, and under the standard of review for this court, this court's going to view the evidence in a light most favorable to Mr. Ruiz Asensio, and when this court does that and disregards countervailing evidence, that leaves us, we're talking about whether or not there would have been sufficient basis for the jury to have entered a verdict for voluntary manslaughter. And given those facts at the fight, and I understand where the court's coming from, there's a sufficient basis to support the murder and the first-degree conviction. And if the lesser-included instruction had been given, we may not have a great argument on the sufficiency of the evidence of the murder of first degree. But likewise, the jury could very well, and it would be reasonable, and it would be reasonably justified in coming back with a verdict of voluntary manslaughter given those facts. So it's not for us to go behind the jury verdict on that or say, well, this is only murder one. The question is whether there was a reasonable basis for it, and given the facts in the light most favorable to Mr. Ruiz and disregarding the contrary facts.
Is that, I'm sorry to interrupt, but the facts that you're referring to,
Yes.
Are those limited to the step towards and the stippling on the body? Those are the only two I've heard you discuss.
And the I don't fear death, which indicates that an assault was imminent. So I think it's a reasonable inference from those things that we know that there's a confrontation. We know that they're going to try to fight him. I mean, those things that we know are true. There is contradictory evidence about whether or not he took a step towards Mr. Ruiz. We know he was close enough that there was stippling plus his I don't fear death. So I think all of those things indicate that Mr. Ruiz was about to be subjected to an assault. And I think when that's the case, that's the type of sudden quarrel that would give somebody a level of fear.
So, but just, I'm sorry to interrupt again, but it would seem to me that the natural consequence of your argument is that any individual who is faced with an imminent assault, but as a matter of law, is in a situation where you can have a heat of passion killing.
Yes.
That that by itself is sufficient evidence to put it to the jury.
I think so.
So you don't
And-
need any evidence of, you don't need any actual evidence of heat of passion or of any of these emotions that you've
Well, I
talked
think you
about.
can draw, I think that you have to have actual evidence, but that evidence can be circumstantial, and you can draw an inference from those facts that a person would be in that mental state. I don't think that it's going to need Mr. Ruiz to testify and provide direct evidence as to his emotional state at the time. And one of the issues I did not raise in there, in the brief, and I honestly don't know what the state of the law is in Kansas regarding imperfect self-defense. Since Mr. Ruiz did not testify about self-defense, but you're asking, and if you're facing an assault and you use an excessive amount of force, but the use of force is justified, but the amount that's used exceeds what is reasonably necessary to defend yourself, we would still be looking at imperfect self-defense, which is a voluntary manslaughter, at least under the laws of the state of Missouri. And I don't know if that, I assume that since that's a common law principle, it applies in Kansas as well. Because he didn't testify and did not establish a self-defense case, I didn't raise that issue. But it does get to your question. If an assault is imminent, a non-lethal assault, is voluntary manslaughter going to be justified? And certainly it's case by case, but I think there's a strong argument in almost every single one of those cases it would be
Well,
justified.
really, just again, assuming all the facts most favorable to your client, it sounds like really all the district court judge had to go on is that there was a proximity between the two individuals, because the powder or stippling on the body and he took a step towards him. I mean, those both really go to prove the same thing, which is proximity.
Proximity.
And then the statement, "I'm not afraid to die."
in the intent.
That's pretty slim, isn't it?
And the ongoing quarrel, that there's animosity here to start with, right?
There is, but whether or not that, I still think that since that, the animosity that may have been between them, and then really the evidence of that goes to the assault charge and the battery on that, but there's enough of a break in time that we can't say that the altercation in the backyard was not sudden. I think that because it was an ambush, because he wasn't anticipating it, he didn't know there was going to be a fight, and next thing you know, he's got two assailants in the backyard, that is the type of suddenness that would warrant giving the instruction. And I understand where the court's coming from in some of your questions. It's not, you're saying, well, it's pretty thin, but I think that that's up to the jury to decide. It doesn't have to be the strongest factual defense to present to the jury in order to justify the instruction. What we need to have is the minimum amount of facts that would be sufficient for a reasonable jury to enter a verdict on voluntary manslaughter. And I think that here there were sufficient facts to support a verdict of voluntary manslaughter, and they would have been reasonably justified in entering that verdict.
Any further questions?
Well, even if we do find error, how do you get around the harmlessness analysis and the skip rule, given that first-degree murder and second-degree murder in both the charges were instructed on?
Because we're asking for the voluntary manslaughter instruction, which was not given. And if the jury had been able to consider the voluntary manslaughter instruction, it is reasonable to think that they could have returned a verdict of voluntary manslaughter, and hence the error would not be harmless.
Well, the question on the skip rule is because they rejected second, why could we believe
I'm
they
sorry.
could possibly jump down to the still lesser voluntary? That's our skip rule discussion.
We don't. Skip rule is the first time I've heard that. That must be Kansas case law. And the answer to that is because manslaughter is an unusual lesser included offense. It's peculiar because it has its own element that is not an element of the murder one or the murder two, because sudden passion is it negates the intent element, but sudden passion is when murder one or murder two are instructed, the court does not instruct the jury to find an absence of sudden passion. And so the jury never considered that, and that's why you don't have harmless error, because the jury never considered that particular element. And I am not familiar with the skip rule beyond that, and I don't know the nuances of that particular procedure. I know that the state did not raise that particular issue.
Any more questions? All right, thank you, counsel.
Thank you, Judge.
May it please the court. My name is Jonathan Noble. I'm Assistant Lyon County Attorney, arguing on behalf of the state of Kansas, the plaintiff appellee in this matter. Kind of as a roadmap, I will only be addressing the issue instruction on oral argument today. The state conceded issue 2, the difference between parole and post-release supervision, and conceded based on this court's ruling in Cash. Turning to the instruction issue, this court follows a 4-step analysis. The first 2 steps are really quick and in and out. The first step is we look at whether or not the issue was properly preserved. State concedes that Mr. Dean, trial counsel, requested the instruction at trial. Second, there's an unlimited review to determine if it's legally appropriate. It is a well-settled point of law that voluntary manslaughter is a lesser included instruction of first-degree murder, where we won't really waste any time there. Thirdly, we look at whether or not there was sufficient evidence in a light most favorable to the requesting party to determine whether they're supporting the instruction. Lastly, we'll look at the harmlessness of the error. First of all, on the sufficiency.
Just on that point, counsel just right before he sat down said something that didn't ring true to me, but I didn't have the document in front of me, and I do now. Page 16 of your brief, you raised the skip rule.
That is correct, Your Honor. I was not the individual who wrote the brief, but we did raise the skip rule, and we argued that because they failed to reach second degree, then it would be illogical to jump all the way down to voluntary manslaughter.
Why is that? And you do know we've kind of modified our the skip rule, making it just a method by which we analyze harmlessness. And basically we say that if they skipped a lesser, that would require the determination of elements and facts that would make it impossible for them to have reached the next one, then that aids us in finding it's harmless. Here, as opposing counsel has said, voluntary sudden oral heat of passion is a different kind of animal. We say there has to be provocation. By definition, there has to be a heat of passion. It's almost like premeditation is negated by provocation or whatever. So that skipping second degree in favor of premeditated does not, in my mind, render a voluntary impossible. In other words, it doesn't make it totally illogical that they might have picked voluntary over first. You understand what I'm trying to say?
I understand what you're getting at. And my response is that premeditation, the jury found premeditation. Therefore, it does not logically follow that because they found malice, they expressly found malice in the form of premeditation, that they would find the opposite by skipping all the way down. By not listening, or by not finding him guilty of second degree, I would certainly, they where it was just intent.
That would have more weight, I think, if premeditation wasn't in the state that it's in this state. We have concurrent premeditation, that you can premeditate during the act, the killing act, according to our cases. And so you could have, I see that you could have premeditated killing, but still be a voluntary manslaughter. If the premeditation was effected or was generated through a provocation that generated a heat of passion. So I don't see that finding premeditation negates the elements of voluntary, whereas it negates the elements of second. You understand what I'm trying to say to you?
I do, Your Honor, but I don't even think we get there,
The
because
hypothetical would be a strangling. Your heat of passion motivates somebody to begin strangling somebody, but it takes whatever it's supposed to be, 4 minutes to kill them that way, and the premeditation can develop during that. That's what he's getting at. So they're not mutually exclusive necessarily in Kansas, are they?
not necessarily in Kansas. However, in the facts of this case, we don't even get to harmless error because sufficient evidence was not presented at trial that would reasonably justify a conviction under the count of voluntary manslaughter. There is a two-part analysis of manslaughter under the heat of passion, whether or not there was a subjective passion, and then whether or not it was objectively adequate, judged by our standards. Specifically, the passion aroused by provocation must be sufficiently extreme to dethrone reason and prevent cool reflection. Here, we can't even just simply assume that he was overcome by terror. We have in the record, and it's not what we want the record to be. It's not ignoring certain evidence, and it's in the light of the entire record. In doing so, we don't reweigh the evidence or pass on the credibility of witnesses. We don't figure out what part of a witness's testimony that we want to accept and what part of it we don't. We just look at the entire record, whether or not there's sufficient evidence. And here there's not. The evidence indicates that for either sudden quarrel or heat of passion. The evidence indicates that the night before April 1st, Mr. Ruiz appeared outside of Armand Nunez's house with a gun. The evidence is conflicted on whether or not he specifically pointed at the head of the 13-year-old or that he was waving it around, but the evidence is very clear that he asked, "Where's Michael Coy?" Between the night before April 1st and the murder on April 13th, Mr. Ruiz drove by Mr. Nunez's sister, Esmeralda or Aldretti, and again asked where Mr. Coy was. So this is a long simmering kind of disagreement. On the night of the 13th, Aaron Gurley, Adrian Peralta, and we're over at Mr. Van Tassel's house. At some point, Peralta went and called Michael Coy on the phone and asked if he wanted to hook him up with Gabino Ruiz. There was some argument back and forth between Mr. Ruiz and Mr. Peralta, but it apparently calmed down. There's conflicting testimony from Mr. Van Tassel. and Mr. Gurley about whether or not Mr. Van Tassel partook in the cocaine use, and why exactly they were being asked to leave. Mr. Tassel maintains that it's because he didn't have a chance at the cocaine, and that he felt that there was an argument ruling between the two parties, and that he characterized it specifically as simmering. Simmering being the same language that was used in this court's decision in State v. Brownlee as determining whether or not there was a sudden quarrel or adequate provocation. They go over to Mr. Gurley's house to secure the TV, which was used in exchange for the cocaine. Mr. Gurley secured the TV, brought it back around front to Mr. Ruiz's truck, put it in the cab of the truck. The testimony from Mr. Gurley was that Mr. Peralta asked them to come around back, said, "Come here." Mr. Gurley testified that Mr. Peralta asked the defendant whether or not he still wanted to fight Mr. Coy, and he said, yeah. There's no indication from any testimony at all the exact order of events. We're kind of left to speculate exactly at what point Mr. Peralta said, "I'm not scared," I'm not afraid of death. We cannot conclusively say that he approached him in any manner. We do know from Mr. Gurley's testimony that at some point he speculated that he got scared, backed up, and pulled the gun. We know that at that point Mr. Gurley's recollection kind of shifts a little bit. He says that once I saw the gun, I turned around and went inside. I'm not sure what happened. I don't know if he approached him. The thing that the only eyewitness that testified specifically as to the actual shooting itself was Alice Garcia, who was another reluctant witness, to be put mildly. She testified that during this exchange, Mr. Ruiz shot Mr. Coy first, the object of his ire, before shooting Mr. Peralta. There was no significance or no medical testimony, no expert testimony offered to any significance of what stippling meant. It's just left into the common knowledge and experience of the jury. Therefore, we don't know what part that would have played. It's certainly not well grounded in evidence. It's kind of left to speculation.
Well, there is some evidence that Peralta had been looking for Mr. Ruiz all night, and then he says he welcomes death before, lunging might be too strong, but before at least there's one account at one point in time that says he walked towards Mr. Ruiz. Wouldn't it be normal for Mr. Ruiz to fear for his life at that point when there's that kind of activity going on? And just in the light most favorable to the defendant, in which we look at this point, where is it that crosses the line, and when would the instruction become appropriate?
We're left to kind of suppose that he felt terror from that situation. He already escalated the situation by pulling a gun. We have no record of any specific gestures, threats, any type of language, and even if we did, gestures and threats by themselves do not constitute adequate provocation under case law. We don't know it was until after Mr. Ruiz escalated the situation and in fact used deadly force by drawing a gun on both Mr. Peralta and Mr. Coy. And the testimony by both Gurley and Ms. Garcia was that while he was holding the gun, he originally had it on Mr. Peralta. We don't know exactly when, and the evidence is a little murky on this point, whether or not at what point after that gun was pulled that Mr. Peralta, I'm sorry, I keep confusing the actual names versus the the street names that they all went by in the record. The victim in this case, we don't know at what point the victim approached and said, "I'm not afraid of death." Presumably, it was already after the deadly force had been shown by him pointing a gun at him. But what is fair to note is that the testimony indicates that he didn't shoot that individual who was lunging for him first. He made the conscious decision to shoot Mr. Coy in the inner thigh and then shoot 9 bullets in extreme succession, placing 2 in Mr. Peralta's gut. We don't know that Mr. Peralta didn't lunge until after he started shooting. So we don't know, we can't even say specifically that Mr. Peralta actually lunged at him. There is not sufficient evidence in the record to show that a jury would have found that voluntary manslaughter was appropriate. I see that I am almost out of time. If there is any further questions, I would...
Well, I've got to ask the question I always ask. If the instruction had been given and the jury had convicted of voluntary manslaughter, and the issue before us was defense challenge to the sufficiency of the evidence, wouldn't you be arguing that yes, the evidence was sufficient for that conviction?
I think you could make that argument for any lesser included instruction.
And I'm not being glib here, because we have a little bit of a split on how we look at it, and how I look at it is, if a jury could have viewed this evidence with its inferences and come up with a verdict of a conviction that could be upheld on appeal as having sufficient evidence, then why do we take that determination away from the jury? Why don't we let the jury make that determination rather than doing it from the bench?
I would have to rely on Justice Rosen's dissent in Qualls, again saying that KSA 2234-14-3 is not a theoretical question. It requires a trial judge who has heard, seen, and evaluated all the evidence in the case to see if there was some evidence which would reasonably justify a conviction. Here, we don't have reasonable inferences for the jury to rely upon. We're asking, the defendant's asking for inferences to be stacked upon one another, which...
Well, if there are no reasonable inferences, then you couldn't, in good faith, argue for upholding the conviction for sufficient evidence. You understand what I'm saying? If you can't have it both ways. You can't say, well, there could have been, but now there wasn't. And so, again, some evidence that they could reasonably convict is kind of a legal standard, whether they could legally convict.
I don't know how else to reply, but to say that...
Well, let me put it another way. Doesn't it take a certain amount, unless there's no evidence, doesn't it take a certain amount of judicial weighing of the evidence to make a determination to be a gatekeeper, not to give a lesser?
Yes.
Any further questions? Any further presentation?
I would simply ask the court to affirm the trial court's ruling in this matter. Thank you.
Thank you, counsel. We thank both of you for your arguments.